amendment, I declare the motion passed. Court's Remote Hearing Bill. The Council now becomes Committee of the Whole Council to consider the Court's Remote Hearing Bill. Members may refer to the appendix to the script for the debates and voting arrangements for the bill. Members have been informed that the committee will conduct a joint debate on the clauses, the schedules, and the amendments, including the new clauses. I now propose the question to you that the following clauses and schedules stand part of the bill. Clauses 1 to 74 and Schedules 1 and 2. The Chief Secretary for Administration will move amendments to a number of clauses and Schedule 2, including the deletion of clauses 41 and 42, and the addition of new clauses 41A, 41B, and 42A. Members may refer to the appendix to the script for details of the amendments. Members may now proceed to a joint debate on the clauses, schedule, and amendments. I will first call upon the Chief Secretary for Administration to speak, but he is not required to move the amendments at this stage. Then I will call upon members to speak. Upon the conclusion of the joint debate, the committee will first vote on the clauses and schedule with no amendments standing part of the bill, then deal with the amendments according to the arrangements set out in the appendix to the script. Chief Secretary for Administration.
Chairman, I move to amend clauses 2, 6, 8, 10, 15, 19, 21, 23, 24, 26, 41, 42, and Schedule 2 of the Court's Remote Hearing Bill. The Bills Committee's members' views have been incorporated into the amendments, which cover 3 major areas. The details have been set out in the paper sent to members. Clause 2, definition of legal representative. First of all, the definition of legal representative under Clause 2 of the bill include paragraph D, that is, any other person who has a right of audience before the court under 1, an ordinance, or 2, a practice direction issued by the court. Taking into account the Bills Committee members' views, the judiciary proposed to substitute the above with an individual who is entitled to participate in that proceeding under an ordinance or a practice direction issued by the court, and take it out from the definition of legal representative by subsuming it under the definition of participant in the same clause to avoid any misconception that persons who have a right of audience before the court are all legal practitioners. Clauses 41 and 42. The rights to attend appeal-related hearings of the defendants. The Bills Committee members note that clauses 41 and 42 of the bill seek to amend Section 83U of the Criminal Procedure Ordinance and Section 36 of the Hong Kong Court of Final Appeal Ordinance. They are worried that defendants may be deprived of their rights to be present at appeal-related hearings, especially for litigants in person. In light of the comments of the Bills Committee, the judiciary proposed to move certain amendments. The details are set out in the paper. The purposes of the amendments are to A, keep the rights of defendants to be present at appeal-related hearings intact, and B, empower the court to dispose of an application for leave to appeal on paper when the court considers it appropriate. The relevant amendments are in line with the policy intent to enhance the efficiency of court hearings and would provide flexibility for the court to deal with applications for leave to appeal however they deem appropriate. The paper disposal approach is limited to applications for leave to appeal and does not apply to substantive appeals. This is because in granting leave to appeal, the court is primarily concerned with whether the grounds of application are reasonably arguable rather than whether the appeal itself should be allowed. Therefore, if a case has clearly demonstrated in the written submissions to the court whether the thresholds been met, the applications can be dealt with by paper disposal without a need for a hearing. This can expedite the substantive appeals which have already been allowed. I must emphasize that it is a case management decision of the court as to whether an application for leave to appeal should be dealt with by way of a substantive hearing, a remote hearing, or a paper disposal. In making the decision, the court will, as always, uphold the overriding principle of justice and take into account all relevant factors and the circumstances of individual cases. If the court considers it necessary to hold a hearing, the defendant's right to be present at the hearing remains unchanged. On the other hand, if the court decides to deal with an application by way of paper disposal and the defendant seeks to attend the hearing, the defendant may still make an application to the court in accordance with the established mechanism. Textual amendments. Lastly, in response to the views of the Bills Committee, the judiciary proposed some textual amendments to make the relevant provisions consistent and clearer. Details of these amendments are set out in the committee stage amendments, and I will not repeat them here. Chairman, the said amendments have the support of the Bills Committee, and I implore members to pass the amendments. Thank you. Ms. Maggie Chan. Thank you. Chairman, I support the amendments to the bill. The administration have taken on board the views of the Bills Committee members as well as me. The amendments amend Clause 2, definition of legal representative and participants, so that there will not be any misunderstanding that any person who has an audience before the court are legal practitioners. This has addressed the views raised regarding legal representative in the BC meetings, and this will address the need of a representative of labor union to speak in the court. The amendments make it easier for workers to understand, and this will minimize any confusion that may arise. Second, on the right of defendants to appear in appeal-related hearing, the amendments keep Section 83U of the Criminal Procedure Ordinance and Section 36 of the Hong Kong Court of Final Appeal Ordinance. I think that this approach of keeping these two sections unchanged is good. Now, the application for leave to appeal will be allowed by way of paper disposal. The court will decide whether the application is considered by way of physical hearing or remote hearing, or by way of a paper disposal. According to my experience, before passage of the bill, applications for leave to appeal and disputes relating to a point of view in law are usually dealt with by paper disposal. So I think that the amendment will keep the rights of defendants to appear in court intact and will allow the court to maintain fair justice in dealing with appeal-related hearings. Mr. Lai Tong Kwok. Thank you, Chairman. I speak in support of the amendments moved by the government. I am a member of the Bills Committee. In the 6 meetings, well, I enjoyed the process very much because BC members and the administration scrutinized the bills together very seriously. And in the end, the government agreed with a lot of our proposed amendments. The amendments may be short, but each amendment will have an impact on the design of the framework. I'd like to talk about repealing clauses 41 and 42 and keeping Section 83U of the Criminal Procedure Ordinance and Section 36 of the Hong Kong Court of Final Appeal Ordinance regarding the rights of defendants to appear or be present at appeal-related hearings. We've talked about this in the Bills Committee meetings, and there's even been media reports on it. If, say for example, the appellant is not legally represented, and if the bill is passed with its original draft, then the appellant will have to apply to the court to appear in the hearing. So I think that there is room for improvement, and I am glad that the government is moving amendment to repeal these two clauses. I think that this is a great move. This will allow the court to make a decision flexibly, and this also protect the rights of defendants to be present at hearings. So this is a win-win situation. I support the amendments. Does any other member wish to speak? If not, I now call upon the Chief Secretary for Administration to speak again. Once again, I thank Ms. Maggie Chan and Mr. Lai Tong Kwok for their invaluable comments. Their views have improved the bill. Thank you. I now put the question to you that the clauses and schedule with no amendment as set out in the appendix to the script stand part of the bill. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. This committee now deals with the clauses with amendments and the schedule. Chief Secretary for Administration, you may move your amendment. Chairman, I move the amendments set out in the appendix to the script, including the amendment to delete clauses 41 and 42. I propose the question to you that the Chief Secretary's amendments be passed. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the amendments passed. As the Chief Secretary's amendment, including the deletion of clauses 41 and 42, has been passed, clauses 41 and 42 are deleted from the bill. Clauses 2, 6, 8, 10, 15, 19, 21, 23, 24, and 26, and Schedule 2 as amended. I now put the question to you that the clauses and the schedule as amended just read out by the clerk stand part of the bill. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. We now deal with the new clauses. New clause 41A to add section 83RA. New clause 41B to amend section 83Y, powers of Court of Appeal under Part 4 which are exercisable by single judge. New clause 42A to amend section 33, application for leave to appeal. Chief Secretary for Administration, you may move the second reading of the new clauses. Chairman, I move the second reading of the new clauses as read out by the clerk. I now propose the question to you that the new clauses read out by the clerk be read the second time. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. New clauses 41A, 41B, and 42A. Chief Secretary for Administration. Chairman, I move to add the new clauses as read out by the clerk. I propose the question to you that the new clauses read out by the clerk be added to the bill. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. All the proceedings on the court remote hearing bill have been concluded in Committee of the Whole Council. Council now resumes. Chief Secretary for Administration. President, I now report to the Council that the court's remote hearing bill has been passed by Committee of the Whole Council with amendments. I move the motion that this Council adopts the report. I now propose the question to you that the Chief Secretary's motion be passed. With those in favor, please raise their hands. Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Third reading, Courts Remote Hearing Bill.